night on the CINA 102.3 app at CINAFM.com, on TuneIn, on Smart Speaker, and at 102.3 FM. CINA Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of CINA Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. تحية طيبة لكم، موعدكم مع حلقة جديدة من برنامج يور رايت والمحامية جومانا كيروز. مكتب المحامية جومانا كيروز يستقبل قضاياكم المتعلقة بالبرسونال انجري، ومن ضمنها كار اكسيدنتس وقضايا الهجرة وقضايا البانكربسي، كريمنال لو، فاميلي لو، وسوشيال سيكوريتي وإصابة العمل. الاستشارات مجانية. 248-557-3645. حلقات برنامج يور رايت يعاد بثها مرة أخرى على الموقع الإلكتروني yourrights.com، وبإمكانكم أيضا الاستماع عليها على اليوتيوب. كل ما عليكم هو البحث عن قناة جومانا كيروز. اليوم هو الثلاثاء، حلقة اليوم مخصصة لموضوع الإفلاس مع المحامي أيضا مايكل بانكستين. جومانا، أهلا وسهلا فيك في راديو سينا.
صباح الخير، يعطيك ألف عافية رامي. صباح الخير لكل المستمعين، وصباح الخير إلى المحامي مايكل بانكستين.
Hi Michael.
Marhaba.
Marhaba.
How are you today, Michael?
I'm very good. How are you guys doing?
Very good, very good. You look relaxed today. I like that. I know you've been working very hard lately.
It's a Tuesday. Who doesn't love a Tuesday?
So does he have every right to be so excited? He's talking about Tuesday as if it's a Friday. Exactly. But it's only Tuesday, Michael.
You know, every day is a wonderful day that you wake up and you can help people get back out on the road, draw a line under things, and get back to debt-free living.
That's a nice answer. That's spoken like a lawyer.
Shukran.
Okay, no comment about what I mean by that, but spoken like a lawyer. Well, we are happy to have you, and we're happy with all the information that you are helping us share with our listeners every Tuesday. We don't like to repeat, but we will say very quickly that our charges in the office for Chapter 7 are $575. There are no hidden fees there. In addition to that, there is the credit report that costs about $20. There is the $335 filing fee with the bankruptcy court, and there is the fee for 2 credit counseling, which is about $60. So the attorney fee or the firm fee is $575. Everything else goes to another entity. Now, like we said before, and I think people are, getting that by now, is for those who are within the 150% of the federal poverty guidelines, if they file for bankruptcy, we will be able to ask the court and get the court to waive for them the $335. That only leaves them with $575 plus the $20 for the credit counseling. I apologize, for the credit score, $25 for the credit report, I apologize, and $60 for the 2 counseling. So having said that, we have talked, Attorney Michael Bangstein, in the past about when you file for bankruptcy, the idea of filing for bankruptcy is to give you a fresh start. When you file for Chapter 7 bankruptcy, and some people want to file for Chapter 7 bankruptcy, but do not qualify, correct? We just want to begin by telling people that just because someone wants to file for bankruptcy, whatever it is, 11, 7, does not mean that the person qualifies. As a general rule, and that's logic, as a general rule, if your debt is less than your income, you cannot, and your resources, you cannot file for bankruptcy. So filing for bankruptcy is a math calculation. And I'm talking here very generally, but that's the general thing. Just because you don't like a credit card debt does not mean that you can file for bankruptcy. You must otherwise qualify to file. So the courts look at the totality of your circumstances, everything you have and everything you own, and you know and all your debts and your income, and they look at all that. So wanting to get rid of a credit card just so that we can start fresh does not mean we can file for bankruptcy. Likewise, Attorney Michael Bankstein, a lot of people want to file for Chapter 7 rather than Chapter 11 because, number one, it is faster, much faster, correct?
That's correct.
And the other reason, I do apologize, I keep saying Chapter 11, I meant Chapter 13. So some people want to file for Chapter 7 because it is faster, it is cleaner, and it wipes the slate totally clean, correct?
That's correct.
Okay.
Most debts are dischargeable in a Chapter 7.
You may want to bring your microphone a little bit lower. Bring it down, push it down a little bit. Thank you. Yes, correct. Thank you very much. Because I can hear your voice a little bit far. So why is it, in your own words, why is it that people prefer Chapter 7? That's what I learned from you.
Well, the main difference between Chapter 7 and Chapter 13 is Chapter 7, from the filing of the case to getting your discharge, that's the part that wipes out the debt and having the court close the case, is about 6 months or less, whereas a Chapter 13 repayment plan is a 3 to 5 year process. So most people do prefer to be in the shorter, less expensive process as opposed to the longer, more expensive process.
Well said. Likewise, a lot of people who qualify for bankruptcy, whether it's Chapter 7 or Chapter 13, want to wipe out all of their debts, from IRS debt, IRS liens, to child support payments, to spousal support payments, to student debts, and maybe other debts. And I just mentioned a number of those that even if you file for bankruptcy, and the philosophy is that bankruptcy gives you a fresh start on everything, it's almost everything, but not quite everything. For example, you can file for bankruptcy, but you still must pay your child support, correct?
That's correct.
You can file for bankruptcy, but you must still pay your IRS liens.
That depends. It depends if you're in a Chapter 7, for example, and if the tax year for which the debt arose is 3 tax years ago or greater, and the tax returns for that year were timely filed, that generally is dischargeable in bankruptcy. But if either one of those things is missing, it's more recent than 3 tax years ago, or even if it was years ago but the tax returns weren't filed until later, then it's not dischargeable.
So tax IRS liens may or may not be dischargeable in bankruptcy.
Well, if it's a lien, that's different. We're talking about just if you owe taxes. If the IRS actually files a lien, then it becomes a secured claim. And then even if it was 3 tax years ago and the tax returns were timely filed, if the IRS puts a lien on it, then generally that has to get paid in full.
Okay, so there is IRS overdue taxes and there is IRS liens. And again, may or may not when it comes to IRS debts.
That's correct.
Liens is a different issue. What about spousal support?
Spousal support also is not dischargeable in bankruptcy.
Okay. let's leave student debts for last because we're going to talk in greater detail about student debts today. Other than these debts that I've just mentioned that are not dischargeable in bankruptcy, meaning you file bankruptcy, you come out of bankruptcy, and you're still responsible for paying them. Other than those, can you think of any other debt that will not be discharged in bankruptcy?
Yes, any debts arising from criminal liability are not dischargeable. Any kind of intentional tort.
Yes.
Not dischargeable. Any kind of fraud in connection with obtaining the debt. So somebody makes $25,000 a year, but they put on an application with a bank that they make $50,000 a year. And then later on they file for bankruptcy and try to wipe out that debt. The bank has a pretty good argument that, but for you having misrepresented your income, we may very well not have provided you with that debt. So any fraud in connection with obtaining the credit itself also is not dischargeable in a bankruptcy.
For example, any fraud on your mortgage application to get a mortgage.
That's correct.
Okay.
Or it could even be a personal loan or a credit card or anything like that. Closely related to that also is it looks like you incurred or you got a lot of debt in anticipation of filing for bankruptcy. So, for example, any debt that you get within the 90 days before the bankruptcy is filed, that significantly increases the likelihood that that creditor is going to object to discharge of the debt. And if they do file an objection to discharge of the debt, the court is required to presume or assume that any debt that you've accumulated within the 90 days before the case is filed they're required to assume that it's not dischargeable unless you can rebut that, and that's a pretty difficult thing to do.
Speaking of intentional torts, my firm represented a client not too long ago whose case involved the sale of real estate. And and we went into private arbitration, and we were concerned that the person against whom we are filing and we have filed this arbitration is going to, go file for bankruptcy after the arbitrator awards an award. So based on what transpired during the arbitration, we were able to make a showing that this person knew what they were doing, intended to mislead and misrepresent. And we asked the judge, who was the private arbitrator, to make sure that in his award, if he finds for us, and he did, to add language in his award that what the defendant did in this case was an intentional tort, because that language means, and sure enough, the judge found to the tune of hundreds of thousands of dollars in our client's favor, and now we know that this defendant is not going to be able to file for bankruptcy and have that debt wiped. This person may file for bankruptcy if he qualifies, but that debt, that judgment, that order from the arbitrator is safe because it was entered based on the intentional tort committed by the defendant.
That's right. That gives you a very good basis to object to the discharge if they're seeking to get rid of your debts in the bankruptcy.
And we've talked before, Attorney Michael Bankstein, about how some people still think, if I am going to file for bankruptcy, let me rack up as much debt as I can on my credit cards because I will be filing for bankruptcy. And that's the kind of thing, will they call that intent or no intent? Will they call that fraud or no?
It's not really
accumulating debt.
It's not necessarily fraud per se, because, but what happens is, again, if that happens within the 90-day window, that significantly increases the likelihood that a creditor is going to object to discharge. And also, every Chapter 7 trustee at your bankruptcy hearing ask you, is the majority of your debt 6 months old or older? So that could raise a flag with the bankruptcy trustee appointed by the court to administer your case if it looks like a lot of that debt happened within the last 6 months or 3 months.
So as we said before, 2 or 3 times already, and in great detail, we'll repeat it again, that those who want to file for bankruptcy should abstain in the 90 days before they file for bankruptcy from racking up any additional debt, because it can be viewed, it can be that they will file for bankruptcy, but those debts will not be wiped out. So the worst that can happen is they will file for bankruptcy, all the other debt that's older than 90 days will be wiped out, but then they're not starting fresh, because all the debt in the 90 days, which is about 3 months, that they added before they filed for bankruptcy is still there waiting for them to repay. And you did say in the past that when clients come to you, and whether they know not to do that or whether they knew what they are doing, they are trying to take advantage of the system. Well, I might as well. I'm filing for bankruptcy. Or whether they were innocent and did not know, the result is still the same. Your advice is, we have some work to do, but let's push the filing of the bankruptcy for more than 90 days from today, so that debt is now older than 90 days. And now if you file for bankruptcy, that debt can be discharged and wiped out.
That's correct. Now, you can't always do that if, hey, you used the credit cards 2 months ago, but now you're facing a garnishment, or there's a foreclosure sale on the house in 5 days. Sometimes you have to kind of pick your battles, but all things being
the lesser
equal,
of the two evils.
Yeah, all things being equal.
Do you lose your house, or do you postpone the filing of bankruptcy?
Right, that's where good lawyering comes in. You know, all things being equal, it is a good idea if someone has used their credit cards within the last 90 days to figure out when the last time they used the card, and then not file it until, 93 or 95 days, or so that's clearly out past the 90 days, and then file it. That significantly reduces the chances that a creditor is going to object to discharge.
And I did speak to a number of people because I wanted to know whether people on the whole, I even spoke to Rami about this, whether people on the whole know that if they're going to file for bankruptcy, they should abstain from adding debt before, within the past 90 days. And the people I spoke to, Rami, you said the same thing. A lot of people don't know. They think that, well, we're filing for bankruptcy, so we have another $1,000 we can put on a credit card, we might as well put it. Yes, Michael, it is very true. Do you agree, Rami?
Yes, of course.
Yeah. A lot of people do not know that you shouldn't do that, because if you do that and you file for bankruptcy, that debt is still waiting for you. So the only way to protect those people is to push the filing of the bankruptcy by another 90 days.
That's absolutely right. And you may see a pattern in there, whether it's fraud in connection with obtaining the debt, or transferring assets away, within a short period of time before you file for bankruptcy, or even incurring new debt within the 90 days. Generally, the court doesn't allow you to use bankruptcy as a shield and a sword. Things happen, you make mistakes, there's a fresh start available, but the court doesn't generally let you use bankruptcy as a weapon to intentionally do things like that and then get off scot-free with it.
And since we are talking about debt in anticipation of filing for bankruptcy, let's talk about something else that we did talk about in the past and that we should repeat again and again. There are conveyances that you engage in within 6 years of filing bankruptcy. There are debts that you repay within to relatives within 1 year of filing bankruptcy, and there are debts that you repay but you prefer one creditor over another within 90 days of filing bankruptcy. So it matters a lot to the bankruptcy trustee if you give things within the past 6 years of filing for bankruptcy, And I want to clarify here, I don't know of anyone who knows that they will be filing for bankruptcy 5.5 years from today. But the court and the bankruptcy code says we don't care. We call it fraudulent. If I gave a home to my daughter, the value of the home is $250,000, and I gave it to her today. She's my daughter. I gave it to her for free. But if, God forbid, I'm filing bankruptcy in 5.5 years or 6 years from today, the court and the bankruptcy trustee will look at that. That's a conveyance, meaning I gave it to, I conveyed it from me to my daughter for free, not for fair market value. If the market value of the home is 250 and I gave it to her for 235, fine. But if I'm giving it to her for zero because it's a gift, because she's my daughter, the bankruptcy trustee is going to look at that as a fraudulent, although there was no intent to defraud anybody. Nobody knew that I will be filing for bankruptcy 5.5 years from now. But the court and the bankruptcy trustee will look at that as a fraudulent conveyance and will consider it as if I still have that money, the value, the $250,000, correct?
That's correct.
And the debts that I owe, if I owe a credit card company debt and I owe my cousin debt and I pay my cousin within the past 1 year and I file bankruptcy today, the court and the bankruptcy trustee is also going to consider as if I still have that money, because I cannot prefer one creditor over another. I'm preferring to repay my cousin's $1,000 when I owe credit card A, credit card B, and bank C this amount. There is no logic to that. So the bankruptcy trustee will act as if I have still $1,000 in my bank account. Same if you decide to get smart and you have 2 or 3 credit cards and you know you are going to file for bankruptcy and you need one of those credit cards, you single out one and you pay it, say, in full, and then you file for bankruptcy within 90 days from when you do it. The bankruptcy trustee will consider as if you still have that money. Now, will the bankruptcy trustee ask the credit card company to give back that money?
If it's a payment to a creditor, to an arm's length creditor, so it's a little bit different than the family members. But if you're paying, if you're preferring
credit
one
card company,
correct. If you're preferring one credit card over another, the court looks at whether or not you've paid that creditor $600 or more over the last 90 days. So if it's greater than $600, then the trustee may avoid, and that's the magic words in the bankruptcy court, or undo that transaction. Now, that's not what happens if you've got a car payment that's $300 a month. That's your normal regular car payment or a mortgage payment. But if you're just talking about, credit card debt, personal loans, things like that, if you pay greater than $600 over the 90 days before you file, the trustee may very well undo that transaction.
Mm-hmm. We have a question from one of our listeners, and this is the question. A creditor is threatening to take my wages. I work and I owe money to someone. He is threatening to take my wages. Can he just do that because I owe him the money, or is there a procedure by which now my creditor to whom I owe money will start taking money out of my wages?
That's a great question. I hear that question quite often. Your creditor can't just take the money out of your wages. If you owe the creditor money, they would have to first sue you and obtain a judgment before they would be able to attempt to collect on the judgment. So one of the things I tell people is, if you get served with a lawsuit, don't wait a month, don't wait 3 weeks, come and talk to us, because you have a 21-day notice period to respond to that. And we could, if you hire us, we can help walk you through how to respond to that so that it gets set out for hearing on a crowded state court calendar instead of getting a default judgment. Because if you don't answer...
So there is a lot of fear with that if you owe somebody money, they're going to take it out of your bank, out of your IRS tax credits, out of your wages. No, they need to take you to court. They need to prove that you owe them the money. They need to prove that you have defaulted. They need to get the judge to issue an order allowing you allowing them to now they can take that order, and if you don't pay on that order, now they can serve your bank. Now with a copy of that order, now they can serve your employer if they know where you're working with a copy of that to garnish your wages. And by the way, I'm not very familiar. I know there are restrictions as to how much of somebody's wages can be garnished. Can all of a person's wages can be garnished? Are you prepared to talk about that?
I am.
Okay.
It's not all of your wages, but they can garnish up to 25% of your gross wages. That's before anything comes out of your check for payroll taxes, Social Security, or what have you. Up to 25% of the gross. That's a pretty significant amount.
Okay. So if there is so again, to answer the question, if you owe somebody money, they can threaten to take it out of your wages all they want, but until you had your day in court and until the judge is satisfied that you do owe the money, you have not owed the money, you are in default of the money, until the judge issues an order, until you default on the order, they are not going to be able to garnish your wages. That is a long procedure. It can take as little as 6 to 9 months, as long as 1.5 years to 2. So just because you owe somebody money does not mean that they have an automatic right to garnish your wages. Same thing, there is a lot of fear surrounding a similar scenario. You know, if I have, God forbid, committed fraud in applying for immigration, and I became a naturalized citizen, can they knock at my door and take me and put me in jail or in prison? Absolutely not. They will have to file a lawsuit. It has to be adjudicated in court. It will take years to prove that you committed fraud, and that had you told the truth, you would not have been entitled to get your citizenship. All that takes months and years and years. It's not automatic. Nobody will knock at your door and jail you, arrest you, issue a warrant for your arrest. It has to be as the result of a civil action. And we have the similar situation here. And another question that we also got has to do, it's a big question. How does bankruptcy affect my credit? Before we wrap up with that, because it's a big question, talking about the fraudulent conveyances. So talking about somebody giving their child a house or their brother a house and then filing for bankruptcy within 6 years of when they gave that conveyance. If you give somebody something for fair market value, you're okay. It's when you give something of value, but you're giving it for no value, that's not okay. So if I gave my daughter the $250,000 home for $230,000, I may be okay. But if I gave it to her as a gift, outright gift, nothing wrong with that. But the law looks at that 6 years from now. That's how the law is written. It's called a fraudulent conveyance. I did not mean to defraud anybody. There was no intent to hide, or no one would know that they will be filing for bankruptcy, 6 years later. But they call it in the law fraudulent conveyance.
And that's a very good point that you made, is that the federal statute does not require a finding of actual fraudulent intent.
But they call it a fraudulent conveyance. Go figure.
That's what it's commonly called, yes.
Right. And typically, it's the bankruptcy trustee who will file, papers with the court alleging fraud, correct?
It could be the trustee. It could also be the creditor who was defrauded.
Right. And there are two kinds of fraud, and we don't want to complicate it for people. It can be intentional fraud, meaning you knew what you're doing, and there can be constructive fraud, where you are not intending to hide or misrepresent. That's why it's called constructive fraud. I want to tell you, since we are talking about fraudulent conveyances, about a Connecticut, in the state of Connecticut, federal jury that a court in Connecticut, a federal court in Connecticut, as a result of a bankruptcy filing, ordered a real estate, very wealthy man who at some point had a reported, a net worth of more than $900 million, to repay back to the bankruptcy trustee $18 million worth of, I believe, assets and cash, because that person, in anticipation of bankruptcy, transferred to his wife at the time assets and cash, property and cash. So this is new. It's recent. It's in June of 2019, where a federal jury in Connecticut ordered the wife of an Irish real estate developer whose worth was more than $900 million back in the day, who filed bankruptcy in 2013 in Connecticut to repay more than 20 million, sorry, that was 18 million euros, $20 million in assets and in cash, because her husband, they found, had fraudulently transferred those assets and that cash to her around the time of bankruptcy. In fact, including $14 million that changed hands in property, the value of a property that changed hands the day of the bankruptcy filing. So again, we're talking about fraudulent conveyances, and whether, someone conveys very, very innocently, or whether, like this person, he was accused of a fraudulent conveyance, and although he transferred all that money, so a lot of people still think that, oh, you're suing me, I am going to transfer. I know this is outside the scope of bankruptcy, but if you're suing me, if I'm in anticipation of litigation, well, I'm moving everything from my name. I'm putting it in my wife's name. And do you have the statute about fraudulent conveyances here in Michigan available outside the context of bankruptcy?
I don't have it in front of me, but I've had some familiarity with it.
Right. And do you know what the statute of limitation is as to that?
I can't recall off the top of my head.
But it was pretty long. It was like 3 or 6 years, if I'm not mistaken. At any rate, within the context of bankruptcy, this gentleman decided to transfer those assets and property to his wife, and this case has been going on since 2013. Now, the bankruptcy trustee, I saw the same name in 2 cases. That's a bankruptcy trustee by the name of Richard Cohn, and he's the one who made the claim, the bankruptcy trustee, against this developer and his wife. How does this $20 million, how does Mr. Cohn, the bankruptcy trustee, get paid?
Well, the trustee gets paid a certain amount just for administering your case. That's a relatively small amount, but they hear a large number of cases every day. But there is a stepped up amount that they do receive for discovering things like preference payments, payment to a family member, fraudulent conveyances. They get 25% of the first $5,000 that they recover. They get 10% of everything over $5,000, but less than $50,000. And they get 5% of everything over $50,000. So that's their buy-in. That's why they care and why they're policing this.
So that's their incentive. So in this case, the bankruptcy trustee who discovered $20.2 million in asset and cash, he's going to get almost 5% of the $20 million. 5% of $20 million. I'm sorry, but I can't.
It's around 500,000 or more.
Half a million is 5%. That, or $500,000 or 1 million actually.
Looks like it's about 1 million.
1 million. 1 million. 1 million. So he gets $1 million out of these $20 million. Very interesting. So that's the incentive for the bankruptcy trustee to do his or her homework on behalf of the creditors and the court and so forth. This trustee, same trustee, also was able to uncover for another, I believe I'm looking at the same case. Yes. So this is from San Francisco, California. The same trustee, Mr. Richard Cohn, I don't know if Mr. Richard Cohn has offices all over, was able to also force someone to turn over $400,000 in assets, such as books, CDs, clothing, cufflinks, sports equipment, and all of that in exchange. And the bankruptcy filing was actually in Connecticut. I take that back. So same court, same federal court in Connecticut, same trustee, and this person who was filing for bankruptcy agreed to turn them over in exchange for the bankruptcy trustee not filing a fraudulent conveyance action against him. So in that case, the bankruptcy trustee will get 25% of the first $5,000 you said?
That's correct.
And then 10% of anything up to
$50,000.
Up to $50,000. And then for the remainder, $350,000 gets 5%.
Yeah, that's assuming it's a Chapter 7. It could be something other, like Chapter 13, Chapter 11. But if it's a Chapter 7, that's the formula. That's correct.
What does one need to do to become a bankruptcy trustee?
Well, it's someone typically who's been an attorney in the bankruptcy court for a number of years. They may
Are
have
these
had,
appointments?
They are.
Do you
They are.
get
There's
appointed?
That's correct. There's a panel of trustees in every district. There's about 94 districts in the country, and typically you'll have a handful of trustees that work all the Chapter 7 cases in that district.
So the panel appoints someone?
Well, you're appointed to the panel. There is a process for that.
The panel appoints to the panel?
No, I've only been at this 12 years, so I'm not in a position to apply for a trustee position. But I do know that there's a process where you're selected, and if they select you, they put you on that panel.
And do a lot of people want to become bankruptcy trustees?
Oh, you can make a lot of money doing that. That's for sure.
Is it difficult uncovering assets? Is it kind of criminal work? Is it kind of civil work? Do you employ investigators? Or maybe a mix of everything.
I've absolutely seen trustees appoint or request to the court that they can hire accountants if there's a lot of accounting forensics involved.
Accountants.
Detectives, real estate people, whatever it takes to uncover the assets. They have a pretty broad mandate to police the financial affairs of debtors to uncover these things.
And does the court benefit financially in any way from the discovery of additional hidden assets or fraudulent conveyances? No, the court applies the law to make sure that the creditors' rights are protected. Because anyone who's hiding money via a fraudulent conveyance or anything else is in essence may or may not be even subject to filing for bankruptcy, but even if, may be defrauding the creditors of money they deserve.
That's correct. To my knowledge, the court doesn't get any of that money, but the trustee appointed by the court does get a percentage.
Fine, but the court is there for the protection of everyone. Debtor protection where applicable, creditor protection where applicable. And with the use of the bankruptcy trustee, who has a financial incentive in uncovering hidden fraudulent assets, there is a financial incentive for the trustee, and the creditors are I'm not going to say made whole, but the creditors are not being defrauded.
That's correct.
Okay. Another question that we got off the air, and I don't know if our time allows us to delve into it in great depth, but we will try. We have about 20 minutes. I take that back. We do have time. Does bankruptcy affect my credit, and how does bankruptcy affect my credit? And I will add, what can we tell people to help them emerge from bankruptcy and rebuild their credit? What a big question.
Thank you. So the fact that you filed for bankruptcy does appear on your credit report for 7 to 10 years, depending on the credit reporting agency. What I have found, though, is that so long as someone is not getting behind on anything else moving forward after the bankruptcy is filed, the farther away in time that you get from the filing of the bankruptcy, the credit score will improve over time. Most people have to get about 18 months out or so after the filing of the bankruptcy before the credit score improves enough for them to start to notice the difference. They'd probably have to be about 4 years out after the filing of the bankruptcy before they could qualify for a bigger ticket item like a mortgage. Although, in terms of getting an automobile loan or getting credit cards, the week somebody gets that discharge order in the mail, they're going to have a mailbox full of credit card applications and, would you like to trade in your vehicle and get a new vehicle, because they know that you can't file another Chapter 7 bankruptcy until 8 years have passed from the filing of the previous case.
So again, we want to tell the listeners what you've said in the past, that the filing itself of bankruptcy is not public knowledge. Your neighbor is not going to know about it unless you tell your neighbor, your family, your friend, your employer. Potential employers can if they ask to run your credit score, and that's purely voluntary between an applicant and an employer. But your employer, while you are employed, will not know about it. Your neighbors and your friends and social acquaintances will not know about it unless you choose to. There will not be a public filing that somebody can search online. We have ways, but the laywoman cannot find those things. So rest assured that people will not know unless you choose to tell them. Why do people not want to file for bankruptcy? I think a big part of it is a feeling that they failed, and that's not necessarily the case. I mean, sometimes it's a change in circumstances, but even if it's not a change in circumstances, well, we all make mistakes. There is not one human being who doesn't make mistakes, who doesn't repeat the same destructive habits. I mean, don't I wish, Attorney Michael Bankstein, that I would engage in a destructive habit once, twice, 10 times and learn from it. I have some destructive habits that I fight every day. And, I can beat myself every time I fall down, but I cannot do that. I have to have faith that I will learn. I will learn and I will make things different. So even those who, so to speak, bring it upon themselves by excessive spending, by not watching their budget, and they find themselves in bankruptcy, this is what it is to be a human. Quite often we learn from what we do wrong, not from what we do right. We have to forgive ourselves. I always get that example of the little toddler who is learning to walk. Do you know how many times a toddler falls down on its head in learning to walk before the toddler starts walking? Hundreds and hundreds and hundreds of times. And imagine if every time the toddler looked at itself and beat itself because it fell yet again, it fell off yet again, it fell off yet again. I wish in a way we have that mindset, that innocence, where we don't label, we don't beat ourselves, and we don't label. It's very hard, but it's so important. I think more important is when we do something to stop and say, how is this hurting us? How is this, preventing us from our goals? And also, there is a bit of psychology here, quite a bit of psychology, Michael. Do you agree with me that when people engage in behavior that's destructive, in the end, they're trying to feel better about themselves, correct?
That's correct. Everybody wants to feel like they have learned from their mistakes.
No, I'm not talking about that. I'm saying when we engage in destructive behavior, when we drink, when we abuse drugs, we're really trying to fill a need. Maybe someone is drinking, right or wrong. Someone is drinking because they are depressed. Maybe someone is drinking because they are lonely. Maybe someone is abusing drugs because they feel that they have no hope in life. Maybe somebody is excessively shopping or going to the casinos because they want to forget the pain that they are in. So the reason is kind of good. It's a good reason you want to do what you can to to pacify the pain, to pacify the reason for why you're engaging in the behavior. It's just that what you're doing is hurting you more than helping you and creating another set of problems. If we look at things this way, there is a lot less judgment on people. Why are people drinking? Why are people gambling? Why are people doing this? Why are people very promiscuous? Why are people... Well, if you peel the layers of the onion, would you agree with me that all of us do this to satisfy a pain somewhere, whether we are consciously aware of it or whether it is subconscious? We're doing it to make ourselves feel better. The problem is that when we do it, we're creating another set of problems. When we are running up that credit card, now we have credit card debt. When we are drinking, now we are hurting our health. We may develop alcoholism and so forth. And the same, whether you get to bankruptcy because of your own poor choices, at some point you did them to feel better. And although there is not a reason to do it again and again, hopefully you can you can think about, okay, why did I do this? Oh, here is why. I did it because of this good reason. I just went about it the wrong way and I created another host of issues. But again, a lot of what we do is imposed. We impose it upon ourselves. When we talk to God and we say, forgive me, but I brought this on myself. And there is mercy for that. That's what mercy is, undeserved grace. It's undeserved, forgiveness. The same here. When we put ourselves in a situation where we find that it's not necessarily because we lost our jobs that we are now filing for bankruptcy, but because we made some poor choices. It helps to remember that maybe we made those choices. We need to sit and think. We need to meditate a little and say, okay, why did I do that? Well, here's why. I was upset and I was recovering from a divorce and I was lonely and I was hurt and okay, I ran up my credit cards and now I am in that situation. And just kind of seek forgiveness. The Constitution, allows you not every year to file for bankruptcy, but every 8 years. But it's there. It's there to give you a new beginning. So I think a lot of people, they feel bad about filing for bankruptcy, not so much because what would people say, because, we've been telling them, and many know that it's not automatically public knowledge that you filed for bankruptcy, but they feel like it's a stamp of failure, correct?
That's
Failure.
correct. And the irony of that, though, is that, for example, if someone had a mishap on the highway and their car was in the ditch, you'd never think that the tow truck is the problem. Somehow people think bankruptcy is the problem, but bankruptcy isn't the problem. Whatever happened before bankruptcy is the problem. Bankruptcy can oftentimes be a solution to the problem. I don't think most people would sit on the side of the road in the car for 6 months and say, well, I don't really want to call the tow truck because that's some admission of failure. The bankruptcy, much like the tow truck, is what will help you get back out on the road, draw a line under things, and restart your financial life.
When people go through credit counseling, Attorney Michael Banks' team, is there any... I've not done this, and maybe I should do this with you and a client once or twice. Credit counseling number 1, which is before you file for bankruptcy, and credit counseling number 2, session number 2, which is before you are discharged from bankruptcy. Is there any attempt at educating people about financial choices and decisions? Can you tell us a little bit about what's entailed, and does it begin to do a good job at rehabilitating people?
Well, the first credit counseling is called budget and credit counseling. They actually go over budget, their monthly income, their expenses, how much are they spending on things, how much ought they to be spending on things for their household size. I've definitely had people come to me afterwards and say, and I've sat in with people doing the first credit counseling also and had them experience that, well, that was really good. I haven't really gone line by line on every single item of what my monthly expenses and what my monthly income is. The second credit counseling is kind of related to that. It's sort of okay, now you're getting your discharge. how do we keep that from happening in the future? What are your larger financial goals that you want to work toward now that you're getting rid of a lot of the debt and keeping this from happening again?
You know, to our defense, all of us, there is something missing in our educational system. There are no courses taught about finance. And let's be honest and let's be clear. Credit card companies don't make money when you pay your bill in full when it's due. They want to keep you ignorant about how you are, paying exorbitant interest because you're only paying the minimal. That's how they make their money. There is no incentive for them. Quite the opposite. So we live in a society where there is really no financial training for us. Not in schools, not in colleges, but then we are expected to make sound financial decisions. And go ahead.
That's correct. I think of my Uncle Glenn, who's had a credit card for probably 35 years. And he's actually not a good customer from the perspective of the credit card company, because I don't think in that entire time he's ever once not paid the balance off in full within 30 days. So they've never made any money off of him. So from their perspective, he's not a good customer.
Right. And actually, and he's so smart because he is living using other people's money, but doing it legally by using the credit card company's money, but by paying it on time and in full. He is not making them any money. He's not making them any money. So again, this question that we started about why people don't like to file for bankruptcy, there is that concern that people may know, then there is that feeling that I failed. You don't fail in life, you learn. Nobody doesn't make mistakes. That's a double negative. Nobody does not make mistakes. Doesn't matter what it looks like on the outside. We all make mistakes every single day. And the sage person, the wise person, is the person who can learn when they make a mistake or when something doesn't go right, if they can stop, reflect back on, if I had to do this again, the hindsight being 2020, what could I have done different? And the sager person, or the more sage person, because I don't think there is a word called sager, the more sage person, the more wise person, is the person who can also look at mistakes of others, and to the extent that you can gain insights about what was done, you read in the news and whatever, it adds wisdom and insight to what you should and you should not do. But again, there is a big psychological thing associated with bankruptcy. But what I'm finding with our clients, and what you've been telling me without telling me, is it's a lot more painful to stand on the edge and say, should I or shouldn't I? Should I or shouldn't I? No. Is there a way? Is there no way? And then once they make that leap, when it's right and appropriate, they find that it's a lot less painful and a lot less scary than they thought it is.
And I see that every day, many times every day. Even earlier today, before I came over to the radio station, in the very first consultation, people come in and it's fear of the unknown. They're scared, they're nervous. But as I speak with them and as we go over their facts and as I let them know what their options are, what their rights are, it's a little different spot in the consultation for each individual, but somewhere in that initial consultation, they sit back in the chair, the color comes back into their face, the breathing slows down, and I've had people say at the end of that very first consultation,
"Thank you so much.
Oh my God,
I feel so relieved.
I don't feel helpless and hopeless. There's hope in the future, that there are options. There is a way to get back on the road."
You are right. And this question that we started, we have barely begun to address it. How much time do we have, Rami? We have only 2 minutes. We will tackle this at a later show. Again, the question is, does bankruptcy affect my credit? Yes, it does. In the short term, it does. But like attorney Michael Bankstein said, the next week that you are discharged from bankruptcy, you're getting offers from credit cards. Are they good offers? No, they're not. They're taking advantage of the fact that you've emerged from bankruptcy. They will be charging you high interest rate, but you will be able to get one if you need it. You may even be able to, get a car. Maybe the most difficult thing, the one that will take the longest, is maybe being able to afford a mortgage. That may take 3 or 4 years. And for you to start really seeing a noticeable difference in the score, it may take 1.5 years to 2. So it's not all that bad. If it's a credit card that you need, yes, higher, but you will able to get one. If it's a car, you may get it way sooner than you think. What else is there remaining? Really, a mortgage for a home, you may have to wait for that 3 or 4 years. We mentioned in a previous show, Walt Disney filed for bankruptcy 7 times, and he came down in the history books. You can only file for bankruptcy every 8 years, correct?
If it's a Chapter 7. There's a number of rules from Chapter 7 to 7, 7 to 13, 13 to 13, 13 to 7.
Right. And again, we just started discussing that, discussing in greater detail that topic, bankruptcy and your credit and how to emerge and recover from bankruptcy. God willing, at a future show, we will be discussing this in great detail. Thank you very much.
Thank you so
Attorney
much,
Michael
Joumana.
Bengstein.
Thank you,
Thank you
Rami.
to all the listeners, and thank you to you, Rami.
ثانك يو جمانة. نشكر لكم مستمعينا حسن المتابعة ودمتم في رعاية